we represent a lot of clients who are charged with mischief, and one of the first questions they ask us is, how do I get these charges dropped? I allegedly damaged the dishes at home, or damaged a car intentionally, or not. I'm innocent, but I want to get these charges dropped. Well, the first step is we need to get a hold of all the police reports, the disclosure, if you will, all the witness statements, the complainant's statement, alleged damage to the vehicle or dishes. Every scrap of evidence that the police gathered, they provided the Crown Attorney, and we get copies of that fairly early on in the process. Once I receive that, I can review that, very carefully analyze it, and determine various issues, like what are the strengths and weaknesses of the Crown case, what's the extent of the damage, is this a minor incident, is there any reasonable prospect of conviction, what do I think I can do with this file in terms of whether A, I can win at trial, or B, whether I can get a great result because it's a fairly minor incident. So for mischief charges, I'm often able to get this charge essentially dropped through various mechanisms. I'm going to then meet with the client after formulating my opinion and provide them with my legal advice, have a full discussion regarding the file, the strengths and weaknesses of the case, what I think I can do, what the options are. And with their instructions, I'm then going to meet with the Crown. One of the important and most important things to do if trying to get charges dropped is you need to take a complete background from the client. You need to learn everything about their life, their prior history, that they're a good person, one-time incident, for example, and be able to discuss that with the Crown in a mitigating and sympathetic way with a view to trying to get the charges dropped, or at least the best possible result. For minor mischief charges, I'm often able to get the Crown to agree, for example, to what's called alternative measures, diversion, diverted out of the court system. Sometimes even if it's a mental health issue, you can get it into mental health court and divert it in that fashion. And what does this mean? Well, the person's got no prior record, they're a good person, they broke the dishes in front of their wife because they're angry, they've done some upfront counseling, they're prepared to do more counseling. The Crown's taking this all into account and saying, look, in this situation, I agree with you, Mr. Kruse, that we should probably divert this out of the criminal justice system. We can potentially go on a peace bond, which is in order to keep the peace and be of good behavior for a period of 12 months, for example, and withdraw the charge. Continue to do some counseling, perhaps. There's all sorts of mechanisms of taking care of these charges. And this often works for minor charges with minor damage. We can often get this done. And effectively, there's no criminal record then. That's often a great result for a person who did it. Some people, even if they're not guilty, choose to take that particular, if they actually didn't do it, they want to avoid the risk of going to trial because there's a chance of losing the trial, even though we may win it. So that's one great result and a way to get a charges drop. Another is if when we look at the file, we go, look, there's no reasonable prospect of conviction here. Their case is so weak, it's circumstantial at best, it doesn't point to the accused, that does happen. I will then try and convince the Crown just to withdraw the charges outright, and I've been successful at times in doing that. It's a fairly low-level test, and that's the test the Crown's supposed to apply. Is there any reasonable prospect of conviction? If there's not, they should withdraw the charge. Is it in the public interest to proceed with the charge as part of the test as well? And if the answer to those questions are no, the Crown should withdraw it. Not all Crowns have the courage to do that. I mean, less experienced ones or ones that are very conservative sometimes push a matter ahead, but of course we'll win that matter at trial anyway, but that's costing the client more money. You don't want to go that route. So part of the process is trying to deal with a more liberal Crown. We know the counties we're dealing with, we know the Crowns, and we try and, where we can, we try and meet with a Crown who's more liberal and inclined to provide us with a better deal. And that's an important consideration as well, to know your Crowns and know their predilections, if you might put it that way, and how they react to these charges. It is helpful when an alleged victim wants the charges dropped, even though the Crown's in charge of the prosecution and the victim, for example, in a domestic type situation of breaking the dishes, even though the victim has no say technically in whether charges are dropped, the Crown will take that into account, at least in a minor situation, either hopefully offer diversion or at worst a conditional discharge. What's a conditional discharge? Well, let's take a situation, perhaps a little bit more serious mischief, where there's more significant damage. And the Crown won't go for diversion, or some Crowns won't go diversion on other cases because they're conservative. They might agree to a conditional discharge, which means you'd be pleading guilty to the offense. There'd be a joint submission in front of a judge that you receive a conditional discharge, which means just that, you're discharged on conditions. In other words, you go on a period of probation, say for 12 months, keep the peace and be of good behavior, maybe some counseling, revocable consent that you can go home, for example, if it's a domestic, if your wife or husband wants you to go home. And effectively, you have no criminal record. You've pled guilty, but you've not been convicted of offense, and you can truthfully say you have a criminal record, and eventually that won't even appear on your criminal record check, although it will potentially for a period of time under the Criminal Records Reform Act that came out in 2018, at least on a level 2 and 3 criminal record checks. It'll show up for a number of years before it's wiped out. You can also get your fingerprints and mugshot destroyed, so your file's destroyed eventually. So eventually it will not show up on any record. It's not supposed to show up on a level 1 criminal record check, by the way, a basic criminal record check, but a level 2 is a criminal record and judicial procedures check, or a judicial matters check. Well, it will show up for about 3 years, I believe. So there's ways and means of sometimes getting these charges dropped. I can't get every charge dropped, but I can often get lesser ones. When it's more serious damage involving thousands of dollars, it gets a little trickier. It gets even a little trickier to get a conditional discharge, but I've even been able to do it, and our other lawyers, on more serious cases. But it requires a person with no prior criminal record, of course. You want a person with good background to do this. When you're getting into prior criminal records and you have a new mischief, you're probably going to wind up with a criminal record unless you can win at trial, of course. And it's all about negotiation skills. It's all about plea bargaining skills and hiring the right lawyer to know it. That's the key. It's just hiring a good lawyer to navigate your way through the legal system. Thank you for watching our video. We are absolutely committed to bringing you the best possible criminal and DUI educational videos. If you found this video helpful, please like it and subscribe to our YouTube channel. If you've been charged with a criminal offense in Ontario and require our services, please click on the link in the description below.